So as we work our way through right of privacy and rights of criminal defendants, I just want you to notice the year that these cases were decided. And once we get finished with all of them, maybe you'll understand why I have nicknamed him Crazy Earl. So enjoy as we work our way through. All right, let's just talk about the right of privacy. So the right of privacy is not in the Constitution. You will not see you have an absolute right to privacy, or Congress shall make no law abridging the right to privacy. You won't see it. The first time that we really saw the concept was in some writings from weeks from earlier cases. But there never had been in the Constitution, never in any of the laws, and never in any of the cases, something that absolutely said that there was a right of privacy. So, as you can guess, this is completely common law, completely judge-made law, and the case where it was started was Griswold versus Connecticut, heard by the Supreme Court in 1965, right in the middle of Earl Warren's tenure as Chief Justice of the Supreme Court. So, I'm going to tell you a secret. Attorneys know. Attorneys know what courts are, who's at the court. They know how courts are tending to rule on certain cases, and state legislatures know it too. So they will, when there is a Supreme Court that seems friendly to their cause, they'll file cases and try and keep appealing until the Supreme Court accepts their case. Supreme Court doesn't have to accept any case. They accept only the cases that they want to. So there was in Connecticut a law that was from, 1879 something. It was old. And it was, Connecticut was highly Catholic state. And in 1879, the law prohibited the dissemination of information. You couldn't even talk about or counsel people on contraceptives or how to purchase contraceptives. That was the law. And it just never was taken off the books. So, Estelle Griswold was actually the director of Planned Parenthood. And so they had been moving along. The fact that there was a Planned Parenthood in the first place meant that they were really ignoring this law. But several people had been trying to get birth control laws or anti-birth control laws up to the Warren Court because they wanted them to change the common law, and they just kept getting knocked down. They kept saying, nope, you don't have the right standing, nope, you're not the right person. So Estelle Griswold brought a couple in, told them about contraceptives at Planned Parenthood, and then made sure that she was charged with the violation of this 1879 law. And then she appealed her conviction. People were watching from all over because they really wanted to see, number one, if the Warren Court would accept this case and what they would do with it. And the Warren Court did not disappoint. They when they get the case, they basically said, we think that there is a zone of privacy that married couples should have when they are making decisions about their family and about reproductive rights. So we just think that should be away from government and away from government intervention. So we just believe that married couples actually have a right of privacy. And yeah, nope, it's not in the Constitution, but we actually think that it's there in the crevices, in the shadows of the Constitution. The word that they used was penumbras. So if you get the essay question that talks about the right of privacy, we're about to talk a whole bunch about unlawful searches and seizures. That's not what we're talking about. And if you start writing about Fourth Amendment unlawful searches and seizures on the right to privacy or right of privacy question, I'm gonna know that you didn't listen to my lecture. What the court said was that if you look at the Constitution, look at the Bill of Rights, you will see that there is an implied right of privacy. So let's just do that. Let's look at the Bill of Rights real quick. All right. So this is what they said. They said, listen, when the founders, or when, I guess, Madison, who drafted most of the parts of the Bill of Rights, wrote that there is a right of people to peaceably assemble, that means that you have a choice with whom you assemble. That must be because you have a right of privacy in making decisions about who you are going to spend your time with. Let's look at the Third Amendment. This is the only time that we'll talk about the Third Amendment. Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner. They said the reason that they wrote the Third Amendment and said that you can't be forced to put a soldier in your house was because there's a right of privacy in your house. Let's look at the Fourth Amendment. Fourth Amendment says the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So maybe the reason, because we have a right to be secure in our persons, houses, papers, and effects, is because we have a right of privacy. Let's look at the Ninth Amendment. Ninth Amendment says that there are rights that are listed in the Constitution, but that doesn't mean that there aren't any more. Just because it's not written there, that doesn't mean that you don't have other rights. And then they went on to look at the 14th Amendment. So not only did they create this doctrine as a common law principle, apply it in this situation, and give it to Estelle Griswold, overturn her conviction, and find the law in Connecticut to be unconstitutional, they incorporated it right there on the spot. This is huge. Griswold versus Connecticut is the first ever right of privacy case. The right of privacy is completely made up, but no less law than anything else. And they found the justification for the right of privacy in the penumbras. Make sure you write that down. In the penumbras of the Constitution. So let's look at that last paragraph again. Protected by several constitutional amendments, including the 1st, 3rd, 4th, 9th, and 14th Amendments by Crazy Earl. So in that instance, they made it very narrow. The right of privacy that they just created only applied to married couples and their right to plan their families. So it was very narrow. It was huge that it had been created, but it didn't apply to everybody. It only applied to married couples.